All right, if council please state names for the record, please.
Kofi Kennedy Swanson on behalf of the Office of the State Attorney.
Cody Jordan with the Public Defender's Office.
Good morning, Your Honor. Rajan Joshi. I'm here on Eric Schmidt. He's in medical.
Eric Smith.
Your Honor, just for the record, I'm going to waive Mr. Schmidt's appearance.
All right, I see that according to the paperwork here, that he had hospitalization and we have charges here alleged: ag assault on a law enforcement officer with a deadly weapon, 4 allegations there, and no bond on any of these allegations. So
Your Honor, I've talked to the state, and the state has agreed he's entitled to a bond to $3,500 on count 1, and I think it was a subsidiary.
150, 150, and 150 on the other counts, Your Honor.
all right, then it is so ordered. So count 1, 3,500, and 2, 3, and 4, the state has agreed to 150.
Yes, Your Honor.
All right, so ordered.
Thank you, Your Honor. May I be excused?
Yes.
It's a pleasure seeing you as always.
All right, the next case is that of Sean Anderson. Is that you, sir?
Yes, sir.
All right, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Office of the Public Defender is appointed. And at the moment, you're in a no bond status.
No addition to a $3,500 bond, Your Honor.
You said 35?
3,500.
All right. Then 3,500 it is.
Thank you, Your Honor.
Thank you. All right, the next file I have is that of Ronaldo Ramos. Is that you, sir?
Yes, sir.
All right, now, according to the paperwork I have, you have looks like 2 Brevard County. Just one? All right, and you're in a no bond status. So, what happens is you'll be transported to Broward County to take care of the case there, sir.
Your Honor, this gentleman has reporting requirements. He has a detainer for a HRSO, high-risk sex offender. With the reporting requirements, you just need to make sure that wherever he goes, he needs to make sure to report that as where he's living.
All right, sir.
Do you understand?
Thank you, Your Honor.
Thank you. Next case is that Susan Lazarine.
Thank you, sir.
Is that you, ma'am? Ms. Lazarine?
Yes, sir.
All right. All right, ma'am, you've got a case here involving a failure to appear at this time, and you're in a no bond status. The charge is attempted first-degree aggravated battery with a deadly weapon. You apparently have not completed the paperwork for appointment of counsel. That could have been previously ordered, but I have no paperwork on that.
She has an attorney.
Say again?
She has the PD.
All right, public defender, I'm advised, has been appointed. That's Division 19.
Your Honor, I do believe this is a competency case. Would it be possible to get her a bond for her to be released on conditional release, given the fact that her attorneys will likely file motions to get her released or get her a bond in this case, given the competency status?
State would object to a bond motion that has not been filed, Your Honor. We believe that the judge that issued the warrant has kept it at no bond, it should be there, and that judge should make the decision.
Well, at this time, the request of the defense is denied without prejudice to seek further relief. And that is Division 19. All right, Roger Christopher?
Yes, sir. How you doing?
All right, sir, you've got a new case involving failure to register as a sex offender in a no bond status. In regard to that, you're also released on a case involving heroin and meth. That bond is stayed at this time. And sir, do you want me to appoint a lawyer for you?
Yes, sir. Thank you.
Public defender is appointed, and that's Division 19 on that new case.
I believe on the new case, Your Honor, he's entitled to a bond.
Yes.
State will request a $5,000 bond because he's out on bond.
Your Honor, I do believe my client is on disability, Your Honor. Social Security, $5,000 would not be reasonable for him to make in order to get released.
Your Honor.
Sir, don't.
I like to talk. I'm big.
All right. Then at this time, the court would set the bond at $5,000.
I got it.
All right, next case is that of David Ewing. Is that you, sir?
Yes, sir.
All right, Mr. Ewing, sir, you've got a set of allegations here. Principal, first degree, and fraudulent use of a credit card, count 1, bond $1,000. Possession of drug paraphernalia, bond $100. Do you want me to appoint a lawyer for you, sir?
Please, sir.
All right, Office of the Public Defender is appointed, Division 16.
Your Honor, does he qualify for pretrial release?
He does meet the criteria for PTR, Your Honor.
He
No
does?
objection.
Yes, he does.
All right, then, so ordered.
Okay, sir.
You need to keep in contact with the trial program. You don't have to be involved.
Okay, what does that mean?
That means that the guy has to ask you to.
All right, next file is that of John Billheimer.
Yes.
Is that you, sir? All right, sir, you've got an open container allegation here. And you also have filled out the application for a lawyer. So that would be granted. Input or offer from the state?
Adjudication, 4 days. Credit for 2 days. 3? Sorry, credit for 3 days.
What's she saying?
4 days. was written agreement.
Your Honor, after speaking with my client, he does wish to enter a plea of no contest and accept the state's offer.
All right. And the plea would be accepted. There would be, let's see, a sentence of 4 days, credit
Okay.
for 3 days at this time, 1 more day to serve, and court cost,
273.
$273 payable within 1 year. All right, the next cases are those of Shelley Reagan.
I'm sorry, Your Honor, Shelley Reagan's medical.
All right, reset. All right, the next file is that of Demetrius Spires. Is that you, sir?
Yes, sir.
All right, sir. Well, you are presently released on a methamphetamine or ecstasy case. That bond would be stayed. Now, you've got a new case involving possession of methamphetamine, and it was set at a $1,000 bond. That has been increased by the court at this time to $3,500 under the circumstances. And sir, do you want me to appoint a lawyer for you?
Yes.
Public defender is appointed, Division 20.
Okay, so you will be able to bond out.
Do I still have an open case?
How much was it, 3,500? Judge, how much was it, 3,500?
Yeah. All right, the next file I have is that of Cornelius Brodus, trespass after warning, bond $500. Is there an offer from the state?
Adjudication 3 days, no return. Credit for 2 days.
All right, sir, is that what you want to do?
I talked about court-appointed lawyer first, judge, the honor.
All right, if you accept the state's offer on that trespass case, you would be sentenced to a total of 3 days, credit for 2, so you have 1 day left. And then court costs,
273,
$273 payable within 1 year.
or 323.
$323. All right, $323.
Has the public defender been appointed to this case, Your Honor?
Sir, do you want to proceed with the Office of the Public Defender?
Yes, yeah, I
right.
signed criminal engine for public defender.
All right. Then the Office of the Public Defender is appointed, so what does that do to the court costs? $323. $323 payable within 1 year. All right, now, if we're proceeding, then it is necessary that he execute the plea form for filing. Otherwise, the plea would not be accepted.
Sir? He's saying to sign. Your Honor, after speaking with my client, he does wish to take the offer and enter a plea of no
All right.
contest.
shit, so.
All right, what are we doing here?
I was trying to sorry for the I was trying to figure out Senior Judge Charles Panther, Ninth Judicial Circuit of the Florida. Yeah, yes, Judge. I would like to take the offer if I could.
All right,
On your signature.
so ordered and accepted.
Senior Judge.
You're asking for your signature. If you don't want to sign
I know it's gonna take a little time.
Sir, if you want to do that, go ahead and sign and we'll move on. If you don't want to, don't sign it.
Your Honor, may we approach?
Yes.
What you talking about? I can't sign it? I don't know how much you're talking about, man. How much you're talking about, man? Fuck you. I seen that talking over my court appointed lawyer, man. What you fucking nigga? Rude. How much y'all talking about? So much. Oh my man. Like I did something wrong. Man. What's his head?
So shall we take a coffee?
My man.
No, I want to inform the court that.
Okay.
If it's a verdict, we can call.
I know what you're talking about, Mr. Silk.
Okay, let's do
Right.
We'll recall the case.
Excuse me, Your Honor. I was doing it wrong. I was just trying to talk it over with my court appointed lawyer. What's going on here?
We're going to recall the case.
Thank you, Your Honor.
All right, next file is that of Arkia Casamehar, if I pronounced that correctly. And, sir, you've requested appointment of the Office of the Public Defender, theft by employee. Is
Judge,
it?
excuse me, this should be Robert Crew.
Hey.
Hmm? Which one? That one?
There's no offer, Mr. Jordan, there's no offer.
That's that one, no, that one that's coming back.
No, that's the one right there. That's the name right there.
I don't understand.
That's the one that's right there in front of you.
Okay.
I don't understand.
All right, now I have the paperwork. We got a charge of trespass on school grounds or facility, bond $250, probable cause exists. He didn't sign the affidavit. So there has been no formal request for the Office of the Public Defender. Can you advise the court as to whether you have previously represented, your office has previously represented this man?
I'm not sure, Your Honor.
All right.
Sir, would you like the public defender to hand you this? Your Honor, he does wish to seek the appointment of the Public Defender's Office.
All right, so ordered.
I believe that's for no return to that school.
All right, there would be an adjudication, no return, and
I don't think there's no clues. She just wants no return.
All right. Let's continue on the status of the case. What are we doing?
I believe the state has no offer.
Correct.
He does seek the appointment of the public defender, and I do believe he has a bond stayed at $250. The state has requested that
All
a
right.
condition of his release, he not return to the school.
Well, the court is going to adopt the state's request at this time.
Okay.
This is Mr. Brodus again, Your Honor.
Okay, here's his picture.
No.
Thank you, sir.
All right, I've been handed the plea form, signed by Mr. Brodus. So there would be adjudication, 3 days, or credit for 2, and the fine again,
$323.
$323 payable within a year.
So you knew already what happened.
All right, the next file is that of Arkia Casamore. Is that you?
Yes, sir.
All right. Ma'am, you've got a charge here, theft by employee. Probable cause does exist. Do you want me to appoint a lawyer for you?
Public defender.
Yes. You qualify. Division 15, public defenders are hereby appointed.
Your Honor, state would also ask a no return to the Dunkin' Donuts on Kirkman while she's out on bond.
Yes, that provision would be added to the conditions of bond, and that's Division 15.
From the Mama State.
Yes. All right, the next file I have is that of Isaiah Fonseca. Is that you, sir?
Yes, sir.
All right, sir, you've got a case here involving an allegation of robbery by sudden snatching. Probable cause does exist. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Office of the Public Defender is appointed. That's Division 12.
Your Honor, we'd be asking whether it would be possible for him to be ROR'd or pretrial release. He has no criminal or juvenile history. Does he qualify for the pretrial release?
No, dangerous crime.
State would object to an RR or PTR. We'd ask for also no contact with the victim, the $1,000 bond, and no weapons or firearms. And no return to the shopping center.
All right, considering the allegations, the court would adopt the state's request. And that's Division 12.
So what is that amount?
No contact, no return, no weapons, no firearms.
35.
You said 3,500?
No, excuse me.
Oh, I'm sorry.
1,000? Okay.
1,000.
Your Honor, I do believe they go to school together. We would request that he be able to attend his last day and his last testing day, which is tomorrow and Saturday, just for the purposes of finishing off his semester this year.
No objection, just no contact with the victim. Don't talk to the
Yes,
victim.
of course.
Pass
All
her in the
right,
hallway.
then, so ordered.
Okay, so you can go to school, just sit down. The whole week. Okay. So post on social media, that kind of thing.
All right, Damian Foster,
Yes, sir.
that you, sir?
Yes, sir.
All right. Sir, you've got a charge here of sexual battery on a child under 12. You're in a no bond status at this time. You've filled out the application for criminal indigent status, and under the guidelines, you do not qualify for appointed counsel.
Your Honor, state will request that the defendant be held at no bond. Looking at the four corners of the affidavit issued by Amanda Strong of the Ocoee Police Department, the victim is 10 years of age. She stated that the defendant would come into her room, had been coming into her room for a while, would get her out of bed, make her kneel on the floor, and he would expose himself to the child, making the child put her mouth on his penis. I believe based on the allegations of not only that victim, but other victims in the affidavit that are not charged at this point, that the defendant should be held at no bond, no contact with the victims or witnesses or the family members in this case, no contact with any children under the age of 18, no weapons, no firearms, no return to the residence. We also ask for no internet.
Well, at this time, those conditions would be imposed, subject to amendment of the order upon motion at a later time. And that's Division 11.
say, or?
Yes.
Private. He does not qualify for the public defender's
To-
office.
It's a toga.
To get his own attorney.
Okay. All right, the next file is that Sergio Green. Is that you, sir?
Yes, sir.
All right, Mr. Green, you've got a charge here of aggravated battery on a pregnant person. At this time, you're in a no bond status. Do you want me to appoint a lawyer for you, sir?
No, I'm all right, sir.
Say again?
No, I'm all right, Your Honor.
He's,
He's okay, he doesn't want an attorney.
okay. No lawyers appointed then. That's Division 14.
Your Honor, if we could request, we have a determination of counsel hearing in a week, if he has not yet retained counsel.
All right, we'll do that.
Right, but he doesn't have an attorney on this case, and he's being held on bond.
I'm all right. For this bullshit.
Your Honor, at the request of the defendant, I
Yeah.
rescind my previous request for the court.
All right, now, he filled out and the application for criminal indigent status. So,
Sorry.
sir, do you or do you not?
Yes, sir. Yes, sir.
Yes, what?
Isn't finished his question.
Oh.
Do you want a lawyer appointed or not?
Yes.
All right, so ordered, public defender is appointed. All right, next file is that of Devontae Heflin.
Says you qualify.
Is that you, sir?
Yes.
Sir,
Yes,
you've
sir.
got a set of charges, looks like 6 charges. Grand theft, third degree of a firearm, bond $150. Carrying concealed firearm, bond $150. Possession of cannabis, bond $100. Resisting an officer without violence, bond $100. Aggravated fleeing, attempting to elude a law enforcement officer with injury or property damage, no bond. And criminal mischief, $150. And, sir, do you want me to appoint a lawyer for you?
Yes.
Public defender is appointed, Division 17.
Your Honor, he is entitled to a bond as to the charge of aggravated fleeing and eluding.
We'd ask for a $3,500 bond as to count 5, Your Honor.
I also note that he does qualify for pretrial release. He has no criminal history, no juvenile history. Is that correct?
All right, now, input on behalf of the state.
No objection to PTR. Your Honor, we would, however, ask no weapons, no firearms, no contact with any victims or witnesses.
All right, that would be so ordered. as requested.
You're gonna get, yeah, you qualify for pretrial release. What that means is, you need to keep in contact with the pretrial release program. They're gonna talk to you about it outside. But you're gonna get out, you don't have to pay a bond.
All right, next file I have is that of Sean Hill.
He's medical, Your Honor.
All right, reset. All right, now, next file is that of Brandon Hopkins. Is that you, sir?
Yes, sir.
All right, Mr. Hopkins, sir, you have a charge of possession of fentanyl, bond $1,000. Do you want me to appoint a lawyer for you, sir?
Yes.
All right? Office of the Public Defender is appointed, and bond is $1,000, Division 11.
Your Honor, he may qualify for pretrial release. They are telling me he does. He does not have more than a single conviction on his record and no
No
juvenile
objection to
convictions.
PTR.
All right, PTR.
Okay, sir. Do you have any questions?
Yes.
Here's some information for you. Keep in contact with your attorney.
Okay.
All right, next file is that of Naphtali Ennis, and a charge of delivery of heroin, bond $7,500 as set by the judge. And, sir, do you want me to appoint a lawyer for you?
Yes, sir.
All right, Public Defenders appointed, Division 10.
Do you have any questions?
And there's a previous judge that entered an order on this, setting the bond at $7,500 with conditions. No possession of any controlled substance without a valid prescription. All right, the next file is that of Kenta Johnson. Is that you, sir?
Yes, sir.
All right, sir, you've got a case here, well, a couple of things. You're out on bond on a set of charges, and that bond totals, looks like $25,150. And in any event, there is probable cause on this new case, and bond well, let me look again here.
There's nothing I can do about that one today.
Your Honor, may state have one moment on this case?
I
Yeah.
believe the out on bond case took place after the allegations in the warrant, Your Honor.
I'm trying to look at the dates, Your Honor.
All right, let me look at this.
No, they're post. I have, on the out on bond case, the 2018 CF 14863. I have that as a 10/16 of 2018 when we received that case. This current case is an 11/13 of last year, so about a month later, I see.
May I have a moment to confirm?
It's coming, over. This date. September 4th.
All right, request by counsel.
Yeah, that's in the.
I understand the witness testimony, but the allegations are from 2015. So,
Say again?
we are confirming the fact that the out on bond case in 2018 CF 14863 took place after the allegations in this current warrant arrest, which I believe, according to the police report, indicated it took place in 2015.
I'm trying to confirm, Your Honor, give me one more moment. I'm just trying to confirm the dates.
And that's why we would be requesting the judge take no action on the out on bond.
Correct, this is the older case.
All right. Then on the new case in Division 20, alleging aggravated child abuse, bond would remain at $10,000. And Office of the Public Defender appointed, Division 20. All right, next file is that of Stephen Johnson.
Sir?
All right, sir, you've got a set of charges here, a total of 8 counts of possession of obscene material depicting child sex. No bond at this time on these allegations.
Your Honor, I believe he's entitled to a bond. I believe the bond schedule is $1,000 per count. State would object to a subsidiary as to any of the counts. We'd also ask for no internet while he's out on conditional release and no contact with any persons less than 18 years old.
Your Honor, given his cooperation with police, we would ask for the subsequent charges to be treated as subsidiaries. No objection to the $1,000 bond as to count 1. All charges are equal.
All right, any further response from the state?
The charges are equal, but they're different pictures.
No, I understand. I'm just saying there's a single,
No, I understand.
the same charge in each count.
No, I understand, but they're different pictures. It'd be different if it was one picture, but he had multiple pictures of multiple children.
I'm
And so
specif-
therefore, state's response would be $1,000 per each count.
All right, at this time, it would be $1,000 for the 8 counts, each of the 8 counts.
It's 10 counts, Your Honor. There's a count page 2.
Say again?
There are 10 counts, Your Honor. There's another page of counts.
Didn't turn the page. Yeah, 10 counts. And Division 22, PD appointed.
Thank you, Your Honor.
Is there any internet? No internet?
Huh?
No internet?
All right, we'll have no internet viewing by the defendant as a condition. All right, next file is that of Anton Ladson. Is that you, sir, Mr. Ladson?
Yes, sir.
All right, sir. You've got a set of charges here. Possession of ammunition by a convicted felon, bond $5,000. Possession of firearm by a convicted felon, bond $4,000. Possession of methamphetamine with a weapon, no bond at this time. Possession of cannabis, bond $250. Possession of paraphernalia, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right. The Office of the Public Defender is appointed, Division 12.
Your Honor, we would ask that he be given bond in the possession of methamphetamine, and we would also ask that count 5 be treated as a subsidiary charge. It is a misdemeanor charge, but they set the bond at $500 in the police report.
Your Honor, state's response would be count 1, be 150, count 2, be 150, count 3, be $5,000, count 4, be 100, count 5, 100, no weapons, no firearms, no illegal drugs without a valid prescription.
We would stipulate to that as well, Your Honor, if that would be agreeable with the
All
court.
right, so ordered, and that is Division 12 if it wasn't announced earlier.
What was the bonds?
150, 150, 5,000, 100, 100. No weapons or firearms, no drugs without a valid prescription.
If you currently possess any weapons, you need to turn them in to the sheriff's office. Just
Thank you.
All right, now the next file I have is that of Darian Lone.
Yes, Your Honor.
All right. Now, the paperwork I have here indicates a capias was issued for failure to appear on a felony warrant with no bond. And I don't know if there was a history here wherein the Office of the Public Defender was appointed.
Yes, Your Honor. The public defender does have this case.
All right. And that would be confirmed. And that's Division 14. All right. All right, the next file I have is that of Jerome Lyons.
Yes.
All right, sir, you've got a charge here, failure to appear on a case involving criminal mischief with damage of $1,000 or more. Now, I have no request for appointment of a lawyer in my paperwork here.
Your Honor, the public defender already is appointed on this case. This is a
All
failure
right.
to appear for,
All right, then that would remain in effect, of course. All right, and the status would remain the same without prejudice.
There was no talk of pre-trial, none of that, because originally there was this failure to appear. There was no court date set originally. They held me for 30 days for criminal mischief and then released me. They said they did not know.
We should do a warrant and make that mistake.
Because I was already held for the criminal mischief and then for 30 days, and then they released me. I don't even live in the state of Florida, so I went back home to Connecticut, and they picked me up on a failure to appear after holding me for 30 days with no problem.
That judge who made the mistake is the one that needs to hear this.
All right, next file I have is that, let's see, Tatiana Smith. Is that you, ma'am?
Yes, sir.
All right, we've got a bunch of paperwork here I need to look at. All right, let's see. Says that there was an endorsed bond. All right, we have here possession of methamphetamine bond, $1,000, false information bond, $100. And refused to come to court yesterday, it looks like. We got here a 2017 case, failure to appear, no bond. Capias for possession of cocaine and paraphernalia bond, no bond. Let's see. Then the case was set, let's see. Yes, by Judge Kest, apparently. It looks like yesterday for a competency hearing.
Did you record this? If they didn't.
All right, input by counsel. We'll go with the state first, followed by the defense.
We asked the bonds be stayed as to this 18 CF 5823, that's a failure to appear, and no bond as to the 2017 CF 11484, we'd ask to be stayed as is, at no bond for the failure to appear. As to 19 CF 8021, We'd ask the bonds be stayed at $1,100 as to those two counts.
Your Honor, the
All
defendant
right,
is,
Public defender appointed. Go ahead.
the defendant has been found incompetent to proceed. She is currently participating in competency hearings as well as court-ordered doctor evaluations. I believe she's been court-ordered to remain in the jail until seen by a doctor in one instance, who will see her shortly. Given that fact, I do not believe she needs to remain detained on the other charges, given that Judge Kess is already handling this as a condition of her release, keeping her in jail until seen by a doctor.
All right, then what we'll do is reset. What's a realistic time period? Anybody have a guess?
Well, Your Honor, the judges in those divisions will set it for a competency status date.
Yes,
So she will go to handle it
All right.
tomorrow in downtown court.
yes.
Okay, that's what we'll do then. Reset for tomorrow, downtown court.
I believe we have to,
We're gonna take no action on the out of bond cases?
Right.
Okay,
We just
so we're
take no
gonna
action?
stay
Stay the-
bonds.
and stay the bonds.
Correct.
We're gonna stay the bonds on the
You're
endorsed.
being
case.
held already.
Okay.
Your judge has ordered
All
you to
right.
be held in
Okay,
jail
we're gonna stay
until
the
seen by a
bonds,
doctor.
no action on the out of bond.
And you have court, so there's not much work, you know. Mhm. And you're getting seen by a doctor here, so those judges will be the ones to handle it. Sir?
All right, the next file I have is that of Joshua Matthews.
Mental health, Your Honor?
Reset. And the next file I have is that of Warren McIntosh. Is that you, sir?
Yes, sir.
All right, now I see that you're out on bond on a case. That bond looking for the case number. In any event, that bond on which you're released is stayed at this time. And then we have a new case involving failure to report as a sex offender to the necessary information. Probable cause does exist on that. Now, sir, at this time, do you want me to appoint a lawyer for you?
Yes, sir.
Public defender's appointed. Now, that's Division 22.
State
on the
request
new-
a $3,500 bond, Your Honor.
All right, so ordered, 3,500.
That would be acceptable, Your Honor, thank you.
Thank you, Your Honor.
Division 22. All right, next file I have is that of Tamara Namey. Is that you, ma'am?
Yes, sir. Yes, sir.
All right. Ma'am, at this time, you have allegations of armed burglary of an occupied dwelling, no bond, false imprisonment with a weapon, bond $150, and aggravated battery with a deadly weapon, bond $150. Ma'am, do you want me to appoint a lawyer for you?
Yes.
Yes? All right. That's, the public defender will be appointed, that's Division 20.
Mr. Jordan, you was at F1 or PPL? That's count one. May I have 1 moment, Your Honor?
All right.
I think it is too. I just want to. I just believe count 1 is a PBL, Your Honor. I'm trying to check. That's why it's a PBL. Your Honor, that was I just want to double check that count 1 was a punishable by life felony. Your Honor, if you look at the 4 corners of the affidavit by Justin Hope of the Orange County Sheriff's Office, this defendant, kicked in the door of the victim, pepper sprayed her, then physically attacked her. When the victim was able to get the defendant off her, she then attacked her. The victim was then attacked by the defendant with scissors, trying to stab her. I believe she did cut the victim's hand several times during the struggle. The victim was finally able to escape and put a chair under the door. She was then able to call 911. I believe the defendant was upset with the victim because she wanted her to leave the home. Based on the violent nature of this attack, Your Honor, inside the victim's room that she was living in, we asked the defendant be held at no bond, no contact with the victim, no return to the scene, no weapons and firearms. Make sure that the defendant understands a weapon can be scissors and not just a gun, and no contact with any victims or witnesses.
That was my home.
Sir, we would argue that the proof here is not evident. According to the police report, the victim is the only person alleging where the fight took place. The independent witness saw a fight in the living room. Our contention here is whether or not the alleged victim was a resident of the home or whether the event took place as the alleged victim attempted to gain entry into the home. It is mentioned later in the police report that it is the boyfriend of the alleged victim who owns residence at that place. Whether or not she is an invitee, whether or not she had right to be there as the boyfriend was not present at the home during the time of the incident, does go to whether or not the defendant here today, whether there is proof evident and presumption great that an armed burglary of an occupied dwelling did take place, as there is no contention in the police report that it was indeed her apartment and her home in which she resided in with other roommates where the event took place. The defendant, I mean. But the victim, it is in question as to whether or not she was or did have permission to enter the place of residence, as well as where the incident allegedly took place. I understand the victim believes it took place in what she says is her room, but according to the boyfriend, later interviewed, who was not present, it was his room, and his girlfriend apparently was the alleged victim. So there's a lot of questions here as to where it took place, whether or not this would be treated as a burglary or this would be treated as assault or so on, or a lesser degree offense. As such, I do not believe there is proof evident and presumption great to hold her without bond in this case.
All right, anything further from the state?
No, Your Honor.
All right. Well, in regard to this, under these somewhat confusing, let's say, facts, bond would be set, count 1, $7,500, and at this time there would be an added requirement that there would be no victim contact, directly or indirectly. That's Division 20.
We ask for no weapons and firearms as well, Your Honor.
So ordered.
Your Honor, given that there is some confusion here, we'd ask that the court put on the record permission for the defendant to return to the residence one time with police in order to gain her belongings and personal things. We're unsure at this time whether the alleged victim does indeed live at the residence, but in an abundance of caution, we would ask the court order that.
No objection to
All
one-time
right,
return of law enforcement.
that would be so ordered. That's reasonable.
Now, I don't know. I don't want you to tell me, but if she's at the home and you cannot have contact with her, even if she's not on the loose, I don't care. You're gonna have to go back one time with police, okay? To do your things. I understand. It's a precarious situation. You need to return with police. So call 911 and wait for them to show up before you go back. If she's there. Don't say anything. Okay? Do some paperwork. Keep in contact with your attorney.
All right, the next case is that of Donald Ray Petty Sr.,
Junior, sir.
or Junior,
Yes, sir.
Junior. All right, now, sir, do you want me to appoint a lawyer to represent you?
Currently, sir, yes. My attorney's not here, so
All right, then we can,
he's not present with me right this second.
I do believe the out-on bond case is also represented by the Public Defender's Office, although he's probably referring to a specific public defender.
I didn't.
all right, then,
I understand.
at this time, in an abundance of caution, the Office of the Public Defender would be appointed as to this case. Now, there is an allegation
Been there 7 years, grandparents.
that he's out on bond on a case, and that bond would be stayed. Now, new bonds,
Your Honor, state will request that we double the current bond to $10,000. He's out on bond for allegations similar to this allegation. No objection to the $150 as to count 2. We ask for $10,000 as to count 1.
Yep, sir.
No contact with the victim, no return, no weapons, no firearms.
Your Honor, there was, at the initial appearance on his out-on-bond case, 2019 CF 7506, the presiding initial appearance judge did not find probable cause and released the defendant on his own recognizance. As such, we'd ask that it not be taken into consideration in this present case, given that there are complicated facts involved in the interest of this case. It does seem that there are some complications in relation to this incident.
all
I
right.
believe
well,
that, Your Honor, on this, to give some more information on that out on bond, the 2019 CF 7506, looks like the state filed an information yesterday and a request to transfer, so it's been filed as a misdemeanor and not a felony. I don't have a case number yet as it was walked through yesterday, but the state did file an information on that out on bond case.
I do not have that case number or information.
All right,
At
bottom
present.
line dollar amount from the state as far as a recommendation. on-
$10,000 as to count 1, $150 as count 2.
You said, once again, 10,000?
Yes, Your Honor.
We'd be requesting a lower bond, Your Honor, given that it even appears that they did not file on the felony, which I'm assuming would be the burglary of a dwelling, his second charge being a trespass. The same issue could be in dispute here as
Well-
to the felony in the first count.
There'd be somewhat of a compromise, if that's the right word. That would be $7,500 no victim contact, and the other requests by the state. Once again, please state those requests for the record.
No
State-
return, no weapons or firearms.
I can't get my clothing, that's,
If that location is in dispute and the court does order no return, we'd ask for one-time return with police.
I have a
Yes.
marshal that's a
Yes,
neighbor,
that's
so-
a fairly customary provision with law enforcement, of course.
I understand, but right now, it is a legal dispute. They're gonna let you back one time with police. Let me just give you some information. Okay, sir? You do have a bond.
All right, Sean Pruitt,
So this is gonna-
Next case.
your name, sir?
Sean Everett Pruitt.
All right, sir. Now, sir, you're out on bond on a driving while license suspended, and that bond is stayed. Now, the new case, driving while license suspended with 2 prior convictions, there's probable cause as to that, and I don't have the application for criminal indigent status. Any input from counsel?
Your Honor, I do believe his out on bond case, he does have a private attorney, Mr. William Orth Esquire,
All right.
I would
Well-
assume.
I do.
So I would assume you get him instead.
All right, well, in regard to the existing and new case,
But that's
the bond
Right now, he's just doing bond.
would be increased from $1,500 to $5,000. And unless and until there's an application for criminal indigent status, counsel would not be appointed at this time. All right, the next file is that of Garrett Sample.
You appointed public defender?
No.
Right, is that you, sir?
Yes, sir.
All right. Now, sir, you've got a possession of fentanyl allegation. Bond is $1,000. You qualify for appointed counsel. Do you want me to appoint a lawyer for you?
Yes, sir.
Public defender is appointed,
Your Honor?
19, Division 19, yes?
We would question whether this, the police report in this case, the facts do rise to probable cause. This is the co-defendant to another case we have here today, Whitlock, I think. Is it Whitlock? But the allegations in the police report are that this defendant was sitting in a passenger seat of a car prior to police arriving. When police did arrive, the co-defendant to this defendant was in possession of drugs, fentanyl, and the officers at post-search of the vehicle, of which the defendant here today was only seen in the passenger seat, did recover additional fentanyl, but I would note that the police report does not mention where in the vehicle they found the drugs and how, in relation to the location of the drugs found, it was in direct possession or he had knowledge of the possession of said drugs, given that it is not clear that he was in ownership of the vehicle, and in fact, he was a passenger sitting in the passenger seat of a parked vehicle. I would question whether there is probable cause to charge him with the possession of the drugs found in a vehicle he was not in ownership of and in proximity to another defendant who was in direct possession of additional drugs of the same type and character.
The state's response would be that you can have joint possession of a drug. The fact that this defendant was the passenger, the occupant of the vehicle, the other defendant, was not in the vehicle. When they searched the vehicle, the drugs were found. We think for probable cause purposes, it does rise to the level of PC.
Well, based on that allegation, the court would find probable cause and appointment of the public defender is confirmed, and that's Division 19.
Your Honor, defendant is active state probation also. He's active state probation, Your Honor.
All right, then anything further?
No, Your Honor.
All right, and of course, if you're on probation, you know, you have provisions to comply with. So, no further action, thank you.
And the bond in this case?
The bond was set at 1,000.
Thank you, Your Honor.
You have a.
All right, the next file is that of Darius Washington. Is that you, sir?
Yes, sir.
All right, sir. You've got a set of charges here: delivery of cannabis within 1,000 feet of a bus, and sale and delivery of cannabis without consideration. Bonds are $10,000 and $150 at this time. And sir, do you want me to appoint a lawyer for you?
No, a public defender.
All right. A lawyer from the Public Defender's Office would be appointed at this time. That is Division 22.
Your Honor, may I have a moment to speak with the state?
All right.
Thank you.
This charge, doesn't there need to be anything else?
I don't think so. I think it's the delivery part. I don't think it's the weight.
22.
What is this? No, I was gonna say it's the basic amount. Yeah, good to be transferred in that. So we'll have to- Gotcha.
Thank you, Your Honor.
All right, now, we have Division 22. I believe I may have announced that earlier, Public Defender appointed. All right, next case is that of Willie Williams. Is that you, sir?
Yes, sir.
All right, sir, you have a set of charges: lewd or lascivious battery, counts 1 and 2, lewd and lascivious molestation. Counts 3 and 4, lewd or lascivious conduct by a person over 18. 2 counts there, no bond. So you do have a total of 6 allegations upon which there is no bond. The Office of the Public Defender is appointed to represent you.
May I have one moment, Your Honor?
All right?
I believe counts 1 and 2 are F2s. I know count 5 and 6 are F3s, and count 3 and 4. I was trying to check the victim's age, Your Honor.
For the record, the alleged victim is 13 years of age. Her birth date,
No, I heard, I just wanted to go to the second page to see it. You're correct. She's 13.
which Your Honor, that would leave us at odds with counts 3 and 4. Lewd and lascivious molestation of a minor younger than 18. The victim being younger than 12 years of age. According to the police affidavit, the victim in this case is 13. And at the time of the alleged offense, the victim had been 13 years of age for a number of months. I would ask the court to find no probable cause as to count 3 and 4 and to set bond in counts 1, 2, 5, and 6.
State's going to request that he be held at no bond for 24 hours while we get the dates of the incident. The problem is that it doesn't say the dates of the incident, and she would have turned 13 in January of this year. So state requests 24 hours to get the dates of the incidences.
All right, well, let's have all the facts correct. So roll it to tomorrow. All right, the next case is that of Davis Kane.
3 days, no return. Past 5 is painful.
All right, your name, please.
Julie Dwight.
Say again.
Julie Dwight.
All right. Now, we have here a, what?
You're skipping that one.
Skipping? Okay. All right, wrong case. Now, we have a case here. Ma'am, you are Julie Dort?
Yes.
Okay, right case. Now, possession of drug paraphernalia is your charge. Bond is $500. Do you want me to appoint a lawyer for you?
Yes.
Public defender is appointed.
The offer is an adjudication credit for time served, Your Honor. She has credit for 2 days.
Yes. All right, so ma'am, I've been handed this plea form here. Do you understand you would be forever giving up your right to a trial if we go forward with a plea at this time?
Yes, but would that mean? Yeah, that means they go.
All right, then there would be an adjudication, 2 days, credit for 2 days, time served, $323 in court costs payable within 1 year. 30 days to appeal. If you cannot afford a lawyer, one will be appointed.
And this is a no contest plea, Your Honor. Thank you. Do you have any questions?
No, I just go. Thank you, sir.
Sir?
All right,
Kane, Your Honor.
Back to this one.
Mr. Kane.
okay. All right, your name.
Davi Stefan Kane, sir.
All right, sir, you have a charge here of trespass on property after warning. You haven't filled out the application for criminal indigent status. Is there an offer from the state?
Adjudication 3 days, Your Honor. Credit for 2.
All right. So, Mr. Kane, is that what you want to do?
I'm not on probation, sir.
And do you want to take the oath? Will you do that?
You are or are not?
He's not, Your Honor.
All right.
You get up tonight.
So, sir, if you enter a guilty or no contest plea, you'd be adjudicated guilty, sentenced to 2 days Orange County Jail with credit for 2 days time served, and court costs $223. Court costs $273 payable within 1 year.
Your Honor, was the public defender appointed to this case?
Not in this case, there's no application.
I plead no contest, sir.
All right? There's a factual basis alleged here, so there would be an adjudication, 2 days credit for time served, $273 in court costs payable within 1 year. And you do have the right to appeal.
Good morning, Your Honor.
All right, sir, your name, please.
Lionel Farron.
All right, so you've got a charge here, trespass on property after warning, and your bond is $500. Is there an offer from the state?
Yes, Your Honor. Adjudication 3 days, no return to the scene, credit for 2 days.
You get up tonight. That'd be
And would that be
Yes, sir.
You take the oath?
I get out tonight.
what? Okay, tell me.
I plead no contest, Your Honor.
All right, then the plea would be accepted. There would be An adjudication, 3 days credit for 2 days time served. No return to this location at 4125 Clarkona Ocoee Road in Orange County. $323 in court costs payable within 1 year. All right, next file I have is that of Danielle James, no, Moses James. Is that right?
Correct.
All right, sir. Now, you have a case of possession of drug paraphernalia. Your bond is $500. You're out on bond on another case. That bond is stayed at this time. Now, is there any offer from the state on this case?
Yes, Your Honor, adjudication of guilt, credit for time served of two days.
So time served for the paraphernalia,
Yes.
and that's it.
This is, they're not taking it.
All right. Yeah. I finally learned 273. Yeah.
Your Honor, was there any action on this out on bond?
No.
No.
Thank you.
No contest.
All right, I'm handed this plea form signed by this individual. So, sir, do you understand you'd be giving up your right to a trial if we have a plea at this time?
Yes. Correct.
Please accepted, adjudication to be imposed. 2 days, credit for 2 days, time served, $273 court costs payable within 1 year. All right, the next file is that of Carrie Rubright.
Yes.
Ma'am, you have a charge of petty theft. Your bond is $250. Now, ma'am, do you want me to appoint a lawyer for you?
A public defender? Yeah.
Yes, public defenders are lawyers,
Yeah.
and you qualify, so Office of the Public Defender would be appointed in regard to this matter.
There is no offer from the state, Your Honor. We would ask for a $250 bond and for her not to be allowed to return to the scene while she's out on conditions of release. Return is Walmart.
Well, the bond would be continued at $250 with no return to 8101 South John Young Parkway, the Walmart there.
Your Honor, if it would be acceptable to proffer some testimony from the defendant, she cannot afford the $250 bond. We would be asking for an ROR. Her last failure to appear was in 2014, and she only has 2 convictions in Florida with no out-of-state convictions.
So I assume then you are requesting that there not be any plea entered at this time.
No, Your Honor. We're simply asking that she be released on her own recognizance pending an information filed in this case.
All right, state's response.
We object, Your Honor.
No, the bond would be required
Your Honor,
at this time without prejudice.
Your Honor, would you be willing to accept a plea to the bench today? The client does wish to resolve this matter.
The state would object, Your Honor, to pleading to any kind of theft-related offenses. The problem is, although the police report lists value, we don't have that total value from Walmart at this time. It could be incorrect or inaccurate. So state would request that we not accept a plea on a theft, as also it is enhanceable. Although I don't see any convictions.
Yes.
On her record, I have learned that sometimes they're not always accurate.
Given the fact that she cannot afford even a $250 bond, she is requesting that she lay herself upon the mercy of the court, Your Honor, and plead to the bench as to this charge.
Well, at this time, pursuant to the defense request, the bond would be reduced to $100 from the $250 amount a public defender appointed. And that's it.
3 days? The offers you get. Your Honor, this is Keith Watkins.
Yes. All right, trespass charge in regard to Mr. Watkins, public defender appointed. Input from the state.
The offer is adjudication, 3 days, no return.
And can I get confirmation from the
It's credit for 2
deputy?
days.
2 days? Okay. Yes, Your Honor, I have spoken with my client about the offer. He does wish to take the offer and enter a plea of no contest. Thank you.
All right. So there's a factual basis stated here. The plea would be accepted at this time, and there would be an adjudication, 3 days, Orange County Jail imposed, and let's see, credit for, looks like 2 days, and no return to this location at 4751 West Sand Lake Road in Orange County. All right, sir, your name, please?
Ernest Felton.
All right, Mr. Fountain, sir, you have a Lake County case, so you would be transported to Lake County, criminal mischief case, to answer to the charges there. Your bond is set at $1,000. All right, the next file is that Televaso Henry.
Yes, Televas's hand.
All right, sir, you've got a Lake County warrant also, no bond. So you'll be transported to Lake County to take care of the case there. All right, next file is that of Joe Warren.
Yes.
Sir, you've got a Polk County case, and you're in a no bond status on that. And so you will be transported to Polk County. And it's on a set of serious charges, looks like. So you'll be transported there to take care of the case, sir.
Thank you.
All right, the
Second session stuff.
The next case is that of Elijah Kraft.
Mental health, Your Honor.
All right, I note that he was also recently. So the Office of the Public Defender would be appointed in an abundance of caution at this time.
Yes, Your Honor. We'd waive his appearance as to today in order to continue with the initial appearance outside his presence.
All right. On, stay, and reset.
Stay and reset?
Oh, no, they waived his appearance.
Oh, okay, are you taking no action on the out on bond? Are you gonna stay at the bond?
Stay.
Oh,
All right, now, how long do council request for recess?
We have Schmidt.
All right, if council would please announce their names for the record.
Kofi Kennedy Swanson on behalf of the Office of the State Attorney.
Cody Jordan with the Public Defender's Office.
All right.
we'll just figure out later.
Yeah.
But I'm
Your
saying,
Honor.
it just go in the.
I have
with the
David's
misdemeanor?
down here if you need any for any of the traffics, if you
When
want.
I get to it.
But
Don't worry about it.
I printed out David's for the traffics if you want.
Oh, okay. Thank you.
Yes, sir.
I know he wasn't on ours, so it was add-on, so I'm saying, was he in the misdemeanor part?
We'll slide.
Which? This? Okay. All right, apparently we're now ready to go, so if council would please announce their names for the record.
Coffee Kennedy Swanson on behalf of the Office of State Attorney.
Cody Jordan with the Public Defender's Office.
All right, thank you. All right, now the first case I have is that of Samuel Camacho. Is that you, sir?
Yes, sir.
All right, sir. You have a case here. Well, you're out on bond on a case. That bond is stayed. And then there's a warrant here that provides for a violation of probation. Do you want me to appoint a lawyer for you, sir?
Yes.
All right, Office of the Public Defender is appointed. All right, now, looking through the paperwork here, we have a $1,000 bond on which Mr. Camacho is released. That bond is stayed. Then we have a violation of probation, and that's a no bond case. Let's see, we got Division 17, and then Division 19, violation of probation. So, sir, do you want me to appoint a lawyer for you?
Yes, sir.
All right, the Office of the Public Defender is appointed.
Your Honor,
Yes.
the defendant has, he's an HRSO, he has reporting instructions.
Has what?
Reporting instructions for,
Okay.
can you explain? Thank you.
So, right now, you have reporting instructions, you have to report any address change and everything.
Yeah.
Right now, your address is the jail. The second you leave the jail, and I understand right now, you're being no bond or a violation of probation. The second you leave the jail, you need to report your new address, even if it is a previous address. And I'm sure that's why it's a BOP instead of like that's why. You still have a bond on the other one. He's not doing any action on that.
All right, now there's a
Okay. You'll see a judge in 7 to 10 days.
warrant here
On the BOP.
providing for no bond nationwide extradition required by interstate compact. Violation of probation, Division 19, no bond.
He took no action on it, so whatever the result was.
All right, sir, you want me to appoint a lawyer for you?
Yes.
All right, public defender appointed. And we have these divisions again, Division 17 and 19, as I recall. All right. That's all for the moment. All right, Matthew Helston.
Yes, sir.
All right, so you've got a set of charges here: possession of cocaine, bond $1,000; possession of drug paraphernalia, bond $100. You have not completed the request for appointment of counsel. Can public defender advise whether you have represented this gentleman before?
Your Honor, I don't have information on that.
All right. Well, there's probable cause, and the bonds are totaling $1,100, Division 16, so that's all I can tell you right now, sir.
You wish to have the bond?
All right, Israel Logan,
He bonded, Your Honor.
all right. All right,
Your Honor, he is requesting that the public defender be appointed to his case. Mr. Helston Matthew?
all right, and are you representing that he will qualify?
No, Your Honor. I would ask that the court proffer information on the record as to whether or not how much money he makes, as well as whether or not he qualifies.
All right, sir, how much money?
How much money do you make?
What do I make? Couple hundred a week, maybe, like that. Couple $100 a week, sir.
On average.
On average, 300, 350.
All right. Do you have any money set aside with which you could hire an attorney?
I mean, a little bit, yeah.
Well, in
Couple
an
thousand, I don't know.
In an abundance of caution, I'm going to appoint the Office of the Public Defender. Let's see, we have Division 15.
No, you already did his case.
Hmm?
You already did his case. You just gotta appoint the PD.
Oh, okay. All right, Public Defender appointed.
Okay, sir, here's some information.
All right, now, Chair Morency. I haven't covered the Chair Morency case. Okay.
That's next.
All right, the next file I have is, let's see.
Chad Morency is in the hospital, Your Honor.
All right, reset. Then the next file I have is Philip Morgan.
You have an inmate number, Your Honor?
Judge, let me see.
Let's see. Huh?
Let me see the paperwork. 1901-7162.
All right. Next file is that of Jason Stiegel.
He also bonded, Your Honor.
All right. And the next file is that of Adria Varela.
No, I don't feel good. Varela, sir.
All right. Ma'am, you've got a case here involving possession of heroin. Do you want me to appoint a lawyer for you?
Yes, sir.
All right, Office of the Public Defender is appointed, Division 22.
Your Honor? According to the police affidavit in this case, we would contest whether there is probable cause found in the four corners of the affidavit, given the fact that the officers arrested and searched the occupants of the vehicle, and the heroin was found on the sole, on a different suspect, Helstein. He was the sole person to have the heroin in his pocket. There is no probable cause for this defendant to be charged in possession of heroin.
Okay, state,
May I have one moment, Your Honor?
yes.
It says in 3/4 in the back seat, in the seat pocket in front of where Adria was sitting, I located a clear zip bag. Inside the bag were 2 hypodermic needles with a clear liquid in them. Also inside the bag were 2 spoons with a white powdery residue. I tested the field tested, presumptive positive in a heroin test kit. That's about 3/4 of it down.
She was not the sole occupant of the vehicles.
Correct. We agree that it's constructive
And
possession
there
case.
was a different occupant in the vehicle who had heroin in his possession as well, and I believe that was the driver of the vehicle. As such, we're suggesting that the occupant with it in his possession and ownership of the vehicle, who had the capacity and control over the objects and substance in the vehicle, was the one in possession of the heroin, not a innocent bystander passenger who may not have been aware of the hypodermic needles inside the car or what they contained.
I think innocent is an extreme term when she's been convicted of drugs in her previous criminal history.
The court at this time would find probable cause and appoint also the public defender, if that wasn't announced, Division 22.
Your Honor, state requests RUA through pretrial release.
All
Random
right.
your analysis through pretrial release.
All right.
Does she qualify for pretrial release?
No. It's just the RUA, it's just the drug test.
Okay. And with the bond, I'm sorry, Your Honor.
$1,000.
Thank you.
All right, the next file I have is that of Willie Foster.
Bonded, Your Honor.
All right. Let's see. Gabrielle Moore.
State has no objection to PTR, Your Honor.
All right. Then, ma'am, your name, please?
Gabrielle Moore.
I have no application for criminal indigent status. Any input from public defender?
Your Honor, after speaking with the defendant, she is willing to put on the record that she does make $900 after taxes and does have a dependent, a child, that she takes care of.
All right. So, ma'am, are you requesting appointment of an attorney to represent you?
Are you requesting an attorney to be appointed to your case? I would be part of the office. I'm part of his office.
Yes.
Yes, she is requesting an attorney be appointed to your case.
All right, public defender appointed. And that's Division A. Yes, all right.
She has 2 cases, Your Honor.
When is
Say
the
again?
traffic?
What?
She has 2 cases. She has a DUI and she also has a possession of cannabis. The state said they had no objection to PTR on both cases.
All right.
Your Honor,
Yes.
with PTR, we didn't qualify for PTR, so it'd have to be bond or PTR if qualifies, because we'd have to do another interview with her. We never got a chance to interview her.
This is Ms. Moore.
Gabriella Moore?
Our paperwork says she does qualify.
If they need additional time, we'd request a bond be set or pretrial release if pretrial release does approve.
All right, then we'll do that.
Okay.
So, or PTR.
And what is the bond set at in both cases?
Total of $1,000 on each. It's $500 as to each.
Okay, ma'am? You have a bond. They're going to conduct an interview, see if you qualify for the bond release. If you do, you will get release, pretrial release, and you need to keep in contact with the pretrial release program. Okay?
Understood.
All right, the next file I have is that of Shirley Pierre. All right,
You're going through a few right now, Montgomery.
all right, next case is that of Antonio Montgomery.
Yes, sir.
All right, sir. Sir, do you want me to appoint a lawyer for you?
Yes, sir.
Public defender appointed. And let's see, we have a bond that's set. That bond is stayed. It's,
We also ask for no return, Your Honor, while he's out on bond.
all right,
Ma'am.
yes.
Sir.
Bond 250, no return to the premises. And looks like that's it, Division A, it says.
Okay.
No action, Your Honor, on out on bond.
Right.
Thank you.
All right. Next case is that of Brandon Vasquez. Is that you, sir?
Yes, sir.
All right. Office of the Public Defender is appointed. You've got a cannabis case. Bond is $250. And, sir, you filled out this application for appointment of counsel. Do you want me to appoint then the Office of the Public Defender?
Yes, Your Honor, if you
All
could.
right. Public Defender is appointed. Division A, it says.
Your Honor, after speaking with the state, they have made an offer in the alternative. They also stipulated that they would not object to release on his own recognizance. After speaking with my client privately, he does not wish to take the offer today, but we would ask the court to consider releasing him on his own recognizance.
All right, state.
No objection to the ROR, Your Honor.
All right, so ordered.
Go to your attorney. Take this.
All right, next case is that of Deshaun Forbes.
Yes, Your Honor. How you
All right, sir. You've got an out-of-county warrant, Lake County, so you'll be transported to Lake County to take care of the charges there. And again, it's a violation of probation situation, and there's no bond at this time. Now, who is this? Who is that? Who is that? I guess it is, 'cause I've got a bond thing.
I'm gonna reset.
Here, I've got this. Said. Which case did we just do? Oh, it was carried over from yesterday. It was mental health, so Any input from anybody in the courtroom on,
Courtroom, okay, well, that's fine. William Scarpelli.
John Doe, where's John Doe?
Scarpelli.
oh, here,
I just wanted to make sure that.
I've got underneath the John Doe paperwork, I've got
In Spanish?
Joseph
Joseph who, Your Honor?
Yep.
Scarvelli?
Yes,
He
He
ref-
refused to attend, Your Honor.
okay. And is this a second refusal? Or do we know?
I believe this is third refusal, Your Honor.
You say,
Second or third, I believe this is third.
It's his second. I believe this was yesterday.
all right, then, under these circumstances, I would appoint the Office of the Public Defender in abundance of caution here.
Your Honor, we'd ask that bonds be stayed at bond schedule, since he's waived his appearance, voluntarily waived his appearance by continuing to refuse to come to court.
Yes,
No objection, Your Honor, and I would waive his appearance as per the court to set bond in those amounts.
all right, I believe that's all.
So you're taking no action. So who is this for?
He has other charges. I do believe he has in.
Out on bond?
Yes.
Yeah,
Those are his?
so that's
So you're taking no
ROR,
action?
so that's stayed on.
Goodness gracious.
Anybody object to recess, subject to call?
State has no objection, Your Honor.
Defense has no objection.
All right, then, unfortunately, we have to recess.